It is very common in bonus schemes or employment contracts to see words such as non-contractual and discretionary in relation to the payment of bonuses. These words can give employers a false sense of security that they cannot be held accountable in respect of their decision-making process in relation to the awards made or not made under the scheme. Employers should be aware that even if their bonus scheme is expressed to be non-contractual or discretionary, it could still give rise to contractual or quasi-contractual rights. In this video, we're going to explore some of the potential pitfalls with discretionary bonus schemes and ways an employer can prevent future disputes. Firstly, it is worth noting that even if the bonus scheme refers to itself as discretionary, this does not mean that it is truly discretionary. For example, an implied contractual right or expectation may have been created by reason of custom and practice, if an employer had paid bonuses on a regular basis, for instance. Even if an employer does have discretion, the discretion is not unfettered, even if it purports to be, as the manner in which the employer exercises its discretion is constrained by terms that are implied into the contract and as established by case law. This includes that an employer must act honestly and in good faith, and must not act in a manner which is irrational or perverse when exercising its discretion. An employer may be in breach of contract if it exercises its discretion in a way that no reasonable employer would have done. The duty on an employer not to breach the implied term of trust and confidence is applicable to the decision-making process in relation to bonuses. It is also worth noting that employers could inadvertently fetter their own discretion by outlining factors that will be taken into account when determining the award in documentation or in an announcement. When communicating the discretionary bonus being awarded to an employee, it would be good practice to set out the following: the amount the employee is being awarded, the reasons relied upon for the decision to award that amount, including detailing any factors that were taken into account or discounted, and the identity of the decision maker. An employer should also keep clear records of the decision-making process should the decision later be called into question. This is of course assuming that the process has been carried out as it should be, otherwise this could be used as ammunition by the employee. It is possible for unpaid or underpaid bonuses to give rise to claims of the following: unlawful deductions from wages, and/or breach of contract or wrongful dismissal, and/or discrimination claims, including on the grounds of a protected characteristic, equal pay, less favourable treatment for being a fixed-term employee or a part-time worker, and/or unfair dismissal. Which of these claims would be applicable, if any, would depend entirely on the circumstances. Firstly, make sure you have a well-drafted discretionary bonus scheme which sets out in very clear terms the scope of the discretion and is tailored to your business. Secondly, make sure that the decision makers understand the scope of their discretion and which factors can be taken into consideration when making awards or not making awards under the scheme. And ensure you have processes in place to record the decision-making process and ensure that it is being carried out consistently and objectively. Whilst it could be tempting for employers to keep bonus schemes and decision-making processes as vague and opaque as possible, this is likely to increase the risk of disputes if the process is carried out inconsistently and decisions are not made objectively.